Shalom Aleichem. It is my greatest pleasure to have joining me Rabbi Shlomo Weissmann of Beth Din of America. I believe he's the Manal Executive Director of the Beth Din, and Rabbi Mordechai Willig, Rosh Yeshiva University, B'tzchak Elchanan, and Rav in Young Israel of Riverdale, and most importantly for this conversation, the Av Beth Din of the Beth Din of America. We are finishing Maseches Gittin towards the end, and I thought it would be interesting for the Lomdei Daf Yomi on this platform and all over to understand a little bit what the prenuptial agreement is, what was its history, what is the actual document, what some of the support or the halachic considerations of this document, and hopefully at the end we'll have some time to speak about the New York Get Law. I talk for myself. I'm an Amoritz in both of these matters. So Rabbi Willig is a person who's been involved in both of these inyanim, and we'd love to hear some of the halachic ramifications of both of these inyanim, and Rabbi Weissmann could talk from a practical perspective what they have done and how they're implemented today. So before I begin, I just want Rabbi Weissmann for 30 seconds to introduce himself and the Beth Din of America.
Sure. Thank you, Rabbi Shwed, first of all, for having me, for having us, and for talking about this topic. I'll talk generally about the Beth Din of America. The Beth Din of America is a Beth Din affiliated with the Rabbinical Council of America, with the RCA. We also have a close association with the OU. And I've been working at the Beth Din for about 15 years. When I tell people what the Beth Din of America does, the answer is we do the things that a typical Beth Din does. And usually I divide that into three spheres. We handle matrimonial issues, ranging from the Seder HaGet, the actual technical implementation of a get. People schedule an appointment, they'll come in, they'll do a get at the Beth Din. Sometimes our involvement with Gittin issues extends beyond that when there's recalcitrance, when things get complicated, when one spouse or another doesn't want to do the get or doesn't want to do the get now is not the appropriate timing for the get, and so we'll get involved in some of the complications in that in terms of azmanas and seiruvin, see to it that there's a process to sort through controversial issues like that. And then our matrimonial practice extends into resolution of end of marriage issues. When people get divorced, they need to deal with financial issues, custody issues, all sorts of disputes that might arise between the parties. And so we'll be involved in mediating disputes sometimes arbitrating disputes in a din Torah. That's kind of one sphere of what one third of what we do. The second third is Dinei Torah generally, where we're helping people resolve commercial cases, business disputes that arise, also through either mediation or through the din Torah process, where typically you'll have a panel of 3 dayanim, and the parties will sign a binding arbitration agreement, and we'll have hearings and issue a psak and work through that, help people try to resolve their disputes. And the third area in which we're involved is halachic personal status issues, where people have questions about, where someone, a Rav has a question, or the community has a question about whether the person's Jewish, whether they're eligible to marry, mamzerus issues, unfortunately, sometimes come up. We have to deal with those. All in all, we do that with a relatively small staff, very busy office, handling hundreds of cases a year in all three of those realms. That's in a nutshell what the Beth Din of America is.
Okay, thank you. The last thing that you mentioned about yichus, so we already discussed. Perhaps we'll have to bring yourself and Rabbi Willig back when we learn Asar Yuchsin, the next Masechta
Right.
for the Lomdei Daf Yomi to have a conversation about. So Rabbi Willig, if you could give, I guess we'll call it a brief shir on the history of what was going on in the world before the prenuptial agreement, what it is, and what's happening now.
Thank you very much, Rabbi Shwed, for your kind introduction and inviting me to speak with Rabbi Weissmann on this very difficult and important topic. I have no choice but to give you a personal history, because otherwise it will be incomplete to understand the whys of my involvement. I'm celebrating, it's hard to believe, 50th year in the Rabbanos in Young Israel, Riverdale. When I entered, almost 50 years ago, the Aguna issue had already surfaced, and rabbis found themselves fairly impotent to resolve these types of situations of recalcitrance. What had changed? Number one, the seemingly exponential increase in the number of divorces. The more divorces you have, the more complicated situations you're going to have. And sadly, in the years leading up to my beginning in the rabbinate, the divorce rate increased, and since then it's increased again. That's number one. Number two, this is not a new phenomenon. Rabbanim today lack the authority of the previous generations to go back to pre-war Europe, or let's say pre-emancipation Europe, at a time when there were organized kehilos, and there was a rabbinate with a chief rabbi, and there was no escaping. You couldn't get away. The only way to get away was to convert to Christianity. Short of that, you had to be part of a kehillah by government fiat. And therefore, there was a significant amount of sway that the local rabbinate had to try to resolve these issues. This, of course, completely fell apart here in the United States and even before that. So therefore, the rabbi has very few means at his disposal to try to get someone who doesn't want to give a get to give one. Very difficult to achieve anything. And that's why these twin developments caused this serious problem when I began my rabbinate. So I decided, as a young man, very young man, that it's not happening on my watch. I'm going to try to do something about it, something. Okay, but I had a honeymoon. The first 15 or so years of my rabbonis, I didn't have a problem. There were a couple of divorces, but the people resolved it themselves. They didn't ask me. The woman never asked me for her help. But of course, like all good honeymoons, it ran out. And in the very late 80s, I was involved in a situation which was precisely such a situation, where after trying to help with Shalom Bayis, etc., the woman asked for a get, and she was right to ask for it. And the man said, if you don't do this or that, you're going to be an aguna. I felt like a bull with a red flag in front of him, that this is exactly what I said I won't let happen on my watch. And now it's happening on my watch. What do I do about it? So I felt we have to tell the fellow, this is not right what you're doing. You should please give the get. And he was a good guy. She was a wonderful woman, both. But just, they couldn't get past it. So the wonderful balabas did what all good balabat would do. He went to a different rabbi. And because he was such an honest person, really, I knew both sides. He told his story from his perspective. To the name of the rabbi was Rabbi Jonathan Rosenblatt of the River Jewish Center. Told him his side of the story, and the rabbi said, yes, we have to give a get. That 2 strikes. It takes 3. So he went to Rabbi Avi Weiss from the third shul then. This is back in 1989, and said his story. And he said again, you have to give a get. All right, now he's sort of struck out, but he's still not giving the get. So after a while, this is right after Sukkot of that year, 1989, we did something which is very rare in our circles today. The 3 of us wrote him a letter, called him up and said, please do not return to our shuls until you give your wife a get. The months went by from after Sukkot until Pesach. And he was not in any of our shuls. He went to some little shul for retirees, a private shul. And then, as it happened, our yeshiva was learning Gittin that year. And before Pesach, I told my Talmidim, listen, we're learning Eidim Mesira Kara, Seder Chasima Kara, all the Lamdus of Gittin that everyone's now finishing in Daf Yomi. Let's do something for Klal Yisrael. Let's just focus from now after Pesach on this thorny issue and try to do something for the Klal. Okay, so we started learning right after Pesach, and the Kodesh Baruch Hu was very good. 3 days after Pesach, a week after Pesach, we started learning. The get was given. What happened? What changed? Well, there's a judge. The judge was a non-observant female Jewish judge who gave the following decision. I'm going to split your assets 50-50, but if you give the get within 10 days, I give you 55%. Instead of punishing him, she rewarded him, which is a completely kosher get. The get was given on Rosh Chodesh Iyar, exactly 2 weeks after Pesach began. That Shabbos he came to my shul. I told the Gabbai, you have to give him shlishi. He says, 6 months, he's persona non grata, and I get shlishi. I said, exactly. For 6 months, he wouldn't give a get, and I gave the get. He deserved shlishi. So he got shlishi. After the next aliyah, I went over to shake his hand. He wasn't so happy as initials, but we're friends. He remarried, she remarried. That's the way. There's a parsha of Gerushin in the Torah for a reason. Okay. Meanwhile, we had started a few days into this parsha. We kept going. So the first thing I discovered in looking at the modern literature was an article which had been written exactly 2 years before. Iyar Tavshin Memches, in a very prestigious halachic journal called Moriah in Eretz Yisrael, Chon Yerushalayim, by a man named Rabbi Tzvi Garten, who I didn't know. Very famous now, but then he was sitting in a kollel somewhere in Meir Shorim. And he had written a beautiful article where he quoted Rav Zalman Nechemia Goldberg, a name which is hardly familiar then also, about a certain approach which apparently had never been discussed before. Many other suggestions have been made. I don't have the time to go into them right now, but none of them enjoyed a broad rabbinic approval. Fine. So someone put me in touch with Rav Zalman Nechemia. I called him up, and he was very, very polite to me. He's a Gadol B'Yisrael, and I was really very, very distant from his level of learning, but it was very nice to me. And we started corresponding back and forth, starting from, we'll say, after Motiv Iyar, all the way for about 8 months we're corresponding. And I realized to move this forward, I have to meet this man in person and see what happens. So it was now up to January of 1991. I flew to Eretz Yisrael to meet this Gadol B'Yisrael. And we meet, we sit, he's always very, very respectful. He and his wonderful Rebbetzin, Aleya Mashal, they both passed away not that long ago. She's the daughter of Shlomo Zalman Auerbach, and she was so nice to me. Amazing. But then he says, after all this, we have 8 months of correspondence already, you can't just do this based on one rabbi. You got to speak to somebody else. One? I said, Rebbe, who should I go to? Please go to Reb Chaim Tzimbalist in Tel Aviv. These were pals from Chevron yet, both Iluyim in their youth. And Reb Tzimbalist was such a great dayan that Rabbi Yosef considered him the number one dayan in all of Israel. How do I know? When the whole Panovich fight broke out and it needed a shalish, he asked Rabbi Tzimbalist to take that responsibility, for which he got bizyonis till the very end of his life, which is, a sign of a good dayan. Anyway, so I went to meet him in Tel Aviv, and I came to his house. He looks over at what Zalman Nechemia had written, says, Zelo motza chen beinai. I don't like it so much. And he turned it around a different way, the opposite way, sort of. The details we'll discuss momentarily. I was so depressed. 8 months I put on this. Rabbi A says this, Rabbi B says that, and nothing on the come of the whole thing. I came back to Zalman Nechemia. I told him, I did what you said. This is what he said. He thinks for a minute and says, we'll do it his way. We'll do it his way. That's, we read on, we say on Moshe Shabbos about the Kodesh Baruch Hu. We see Gadluso, you see Anvesanuso. One of the proof texts from this week's Parsha, Parsha's Ekev. I saw it in my own eyes. In a heartbeat, he said, okay, we'll do it his way. After he had printed the other way 2 years ago already. It's now almost 3 years ago. We'll do it his way. Good? So I'm back and forth and back and forth and back and forth to get proper conclusion. Fine. I go back home. At the time, I was helped by a group called the Orthodox Caucus, which helped me. And they had a whole bunch of lawyers to make sure that it's going to be workable from the perspective of American law. Otherwise, it's worthless. It took me another whole year to get a proper draft, and I went back the next year. This is now January of 92. And that's when I have some time off from the yeshiva. And I went again. And I went also to Rabbi Ovadia Yosef. How I got to know Rabbi Ovadia Yosef is another long story. But in that month that I was there, in those 2 weeks, he gave me both a haskama on my Sefer Mordechai, and he had comments which on his beautiful handwriting in his blue pen on some of the earlier drafts. And by the time I left, I had a draft with signatures, first from Zalman Nechemia, then from Rabbi Ovadia, and then I went to Tel Aviv to the Symbolist. They all three signed. This is a proper, it's dated, I think something Shvat Tovshin Nun Beis. It's a date on it. Done. Came back to America, and I worked on it. We just went to work. I got 2 additional haskamas in America. First from Rabbi Liebes Zal, who was a very distinguished and famous Rav from the Igor Rabbanim, then from Rabbi Schwartz, that's Zal, from the Beth Din of America. So now I had 5 distinguished Rabbanim, 3 from Israel, 2 from America, done. I had asked a number of others, whose name I shall not mention right now, and they said, it's okay, but like NIMBY, not in my backyard. It's not happening in my community, which sadly caused a lot of grief since then. Fine. We went to work. We did it. Okay. Now, some of the details. What does it say? What does it say over there? So a little halachic background. What happens if a couple is married? So we all know the Torah says he's obligated to support her. What happens if they're no longer living in the same house? What's the din? It's clear in Shulchan Aruch Even HaEzer Siman Ayin. It depends whose fault the breakup is. If the breakup is his fault, he must support her. If the breakup is her fault, he need not support her. Now you understand very well that in our world of no fault, there's no fault, car insurance, everything's no fault, because till you find fault, she'll turn white till we discover whose fault it really is. So what this does is tries to close that gap. It says he's obligated to pay her a reasonable amount. Originally was $100 a day. Rabbi Zalman wrote in this original article in 1988, $50 a day, that's the amount that costs for full room and board in a hotel. I'm not sure what hotel he had in mind. But anyway, so we upped it then to $100 a day, which was considered a reasonable amount at that point in time, until about 1992. We went to work, and it's been in effect ever since. So what does it say? Aside from the arbitration agreement that is going to go to the Beth Din of America if there's a problem, but there's also a paragraph which reads more or less like this. I, the undersigned, hereby obligate myself, what's called Me'achshav, that in case the parties break up, no longer living residents together, I hereby obligate myself to pay her a sum of $100 a day. Of course, if I refuse to abide by what the Beth Din says, then of course, I have to pay. If she refuses to abide by the decision, the recommendation of the Beth Din, then it's a different story. Otherwise, she'll have to hold them up forever. And there was some other verbiage. Yes, please.
So essentially, what's happening is that we're giving Rishus permission to the Beth Din to decide fault, or they're going to come together? Is that how we're doing
that?
That's not
the answer. The answer is even if, he's saying that even if the fault is not mine and the fault is her fault. So if you go with the strict laws of Shulchan Aruch Even HaEzer, I need not pay any money. Nonetheless, I decide to accept upon myself, I'll pay her anyway, which is 100% permissible. We'll get to some of the details later. In addition, there's another clause that he waives his rights to her earnings, because very often she's making much more than $100 a day, do the math, and therefore she'll say, okay. So you give me, he'll say, fine, I'll give you $100 a day. You give me $300 a day from your earnings. So what did it accomplish? That's also put in there as a. There are other phrases we'll perhaps get to a little bit later on. This is how we've been going with that assumption. And we've been going with that assumption ever since. In terms of later developments, so I think the year was 2008. So the original Hebrew was very spare. There's a few lines. And we had made a number of emendations and additions. So it was only right that we be translated from the English to the Hebrew. So Rabbi Gartner took a pen in his hand and translated the then English into Hebrew. We went back to Zalman Mordechai, he signed his name again, and a new star on the horizon, Rabbi Usher Weiss Shlita, who signed his name on it again. He even wrote a very nice letter of recommendation to myself and Rabbi Gardner supporting it, and we were very happy to have his support. He's a very big Talmud Chacham and very well known in broader Torah society. Okay, so this is the very basic outline. Now, are there objections? Yes, there are objections. There are objections. As a matter of fact, I was asked to go to the greatest dayanim of the time. I was asked to go to Rabbi Shlomo Zalman, his son-in-law told me not to go because won't be able to help you. He was right. He smiled at me and said, Lech ledayanim. Also asked me to go to Rav Yashiv. That's already a different personality. It's very hard to get into Rav Yashiv. Very hard to get into him. And when I finally got into him, over the objection of his main associate, Rabbi Efrati, whom I know personally, said, don't bother the Rav. But I got into someone else who got into his Rebbitzin. You know how it is. So Rabbi Efrati was a very big gentleman. Even though I got in over his head, he still introduced Rabbi Yashiv as someone who's b'machaneh shalanu, who mishalanu. And what was the mishalanu? Said he got me in how did I mishalanu? The two raging debates of the day. I was both on his side. First was the brain death issue, and the second was the New York get law issue, which maybe we'll get to later on. So with that introduction, Rabbi Yashiv smiled at me and said, go to Rabbi Morgenstern. He is another very important associate who was American born and trained, a very, very smart man. He'll tell you what I think of this. And he told me one issue was, which is printed by Rabbi Gartner in the original article, the person will not know what he's signing. Yeah, again, average chassid doesn't know what he's signing. Now, you think he knows what he's signing when he signs a ksuba? He doesn't even know the language. So I thought, so what? Who cares if he doesn't know it? It's obligated anyway. The Rashba says so, Shulchan Aruch says so. That was objection number one. Objection number two, that he thought it might end up in court. Of course, it's the opposite is true. This keeps it out of court. Objection number three, I don't understand, is that, he may want to be giving a get, which otherwise he may not want to give. Well, that's exactly the point, as long as it's kosher lahalacha. The fourth objection, which I understand very well, is something called asmachta. Now, asmachta means a person who obligates himself on a contingency. And there's many, many details. Time was not allowed to go into every last detail of the asmachta issue. Asmachta lo kanya. And we attempted to overcome that issue in a number of ways. Number one, according to many authorities, based on the Mishnah above Siyadaf Kuf Daled, it's only an exaggerated obligation. That's a problem. We felt ours is not exaggerated. We're estimating how much it costs to live. That's number one. Number two, with certain technical statements. If a person says he's doing it me'achshav v'bezdin choshuv, that seems to overcome asmachta according to the Shulchan Aruch, and that's why we thought we have overcome that problem. Now, as one very smart lawyer from Israel told me once, wrote to me, you know why Rabbi Yashiv is against it? Because he wrote a tshuva that he thinks asmachta is a problem, even if you write kinyan me'achshav v'bezdin choshuv, he felt that it's still a problem with respect to accepting obligations. It may not be a problem with respect to transferring property, but still with respect to accepting obligations. My personal view is that Rabbi Yashiv, now Zatzal, is 100% right according to the Rambam. I think so. However, I do believe it's not correct according to the Shulchan Aruch. Time was not allowed to go into the details of sugya about an orev and choshen mishpat. Okay. But remarkably, Rabbi Yashiv never came out against our prenuptial. Rabbi Yashiv knew how to come out against things, as we well know. He was famous for it. Never. I have a theory as to why he never came out. I can't prove it. Rabbi Yashiv's tshuvas and Kovas tshuvas Aleph and Beis, Siman Kuf Samach Gimel, the same number. In one, he says what I just told you, that there's a problem, according to the Rambam. But in two, he has a very simple question. How can any ksuba obligation you add to it, Tosefes ksuba, apply? It's asmachta. He doesn't expect to have to pay. He doesn't expect to have to divorce his wife. So why then is it effective? So Rabbi Yashiv has a great answer. He's based himself on Gemara Masechta Kiddushin and Ksubas. It says over there, Kama tanos the bincha, Kama tanos the bincha, Omda v'kitshu, Hein advrama nikna ba'amira. Hein advrama nikna ba'amira. That means that you don't need a kinyan. If you don't need a kinyan, asmachta lo kanya is irrelevant. That's what Rav Yashiv wrote in that tshuva. Of course, based on that, our prenuptial is good, even if it would be an asmachta. But we don't think it is in any event. That's my theory. Yes.
So the third reason that you were saying about that he's giving it against his will. Does that touch on which you said I don't think is a problem at all because that's what we wanted to do? Does that touch on the get ma'usa, or that's a totally separate?
I cannot answer that question. I don't understand what he meant. The person gives the get, he doesn't want to. Let's say he doesn't sign a prenup. So he has to give her a mizonos, okay? So he's giving her a get because he doesn't want to give her the mizonos. So that's a good get. Every get is that way. So I don't fully grasp it. That's why I can't comment in detail. Okay, it's interesting. A postscript to that. A couple of years later, this is now Tufshin Nun Hey, 2 years later, two things happened. One, they asked me to print I wrote a whole article in Moria. But Rabbi Buchsbaum Zal said you can't print it unless Rabbi Yashiv says you can print it. So I went to Rabbi Yashiv and he said, no, don't print it. So it's never been printed since then. I still never printed it. I feel that Adam Gadol, the Gadol Ador said, no, I shouldn't print this. I'm not printing it. All the substantive facts are strewn over my last sefer. A little here, a little there, a little here. The substantive facts that I'm allowed to print, but the whole article is still in my hand. But another thing happened the same year. A few months later, there was a very remarkable shidduch to the young lady from the Hebrew Institute of Riverdale, Rabbi Avi Weiss, and a young man from the yeshiva Far Rockaway. At that time, the assistant to Rabbi Per was a Rosh Yeshiva. The first prenup came from Rabbi Per. Tshuva for Rabbi Moshe said, just sign a prenup, you're going to go to this particular Beth Din. That's all. So that's very important. That's sort of a kind of an arbitration agreement, which Rabbi Moshe said is good, which is obviously good. It's like a mother and an apple pie. It certainly is good. And I should interject now. Last year, they made a Heskem in Brooklyn with a Heskem of everybody. Rabbi Shlomo Miller, who was considered the person now in Lakewood, also signed on to it. And guess what? No traction. Zero traction. It's not going anywhere, which indicates what I've said all along. The main reason why our prenup was not accepted in the Olam HaYeshivas is not because of the substance, because it's something which is considered to be new. Chodesh Asam in Torah. V'harayir, Rabbi Shlomo Miller, their posek, and many others signed on to something and it's still not being used. That's the real reason. So as a matter of fact, this gentleman, Rabbi Kaufman at the time, now he's in Waterbury, says to me, what do I do? My shver is Rabbi Shraga Fayavl Cohen. Now is that Sal. And what do I do? I said, I spoke to him a few years before. He said it's okay, just that, and I knew he'd say it's okay. Asmachta could not be a problem according to him. He wrote a beautiful little kuntras called Midora Dora about Yerusha. It's all based on the Shtar Chatzizacha with exactly the same type of a asmachta, but much more difficult than ours. It's to an exaggerated sum. And he still felt it was okay. So I knew he couldn't object, even though he was the number one chassid of Rabbi Yashiv. In this particular din, he didn't agree. He said, asmachta works. Fine. Anyway, getting back. So, yes.
If Rabbi Willig could spend 2 minutes, if possible, just giving what is an asmachta. There might be people listening. What is asmachta?
Okay,
then they can follow.
I said it briefly at the beginning. It's an obligation made upon a contingency. If this and this happens, the case of the Mishnah, im over v'lo avid, if I will not work your field, ashalem alfa zuzi, I give you 1,000 zuzim, which is $1 million. That's not valid. Im over lo avid ashalem b'meitva, I'll just pay you what I cost you. That works, which is one of the reasons why the non-exaggerated sum may work. There are other ways to skin that cat, but not for now. Okay, contingency obligation. But as I mentioned earlier, every ksuba is that way. In cases of divorce, I'll give you a lot of money. So, okay, let's go back. So at that point, I wrote to Rabbi Cohen a one-page memo. I faxed it to him. Remember faxes? I faxed it to him, and I have the original. And I wrote the 4 objections that Rabbi Morgenson told me to the opinion of Rabbi Yashiv, and Rabbi Fayavl Cohen told his son, Rabbi Kaufman. There's notwithstanding that, feel free to do the wedding with this prenup. So that's just a historical fact going back to 1995. Fine. So we're meandering along, time goes by, and we find, as Rabbi Weissmann will fill you in, that it's very successful. Why is it successful? Because an individual who has an obligation which is enforceable in the secular court, that he has to give $100 a day, then he is less likely to be recalcitrant. He can, no problem. He can, but it's just less likely. Most people are not interested in giving money to a woman that they're no longer living with and they may no longer love, they may actually hate. So it's been very effective. Now, there have been some challenges to it. I'll give one example. I think it was in Connecticut. Someone said it's unconstitutional because it's a violation of certain church-state things, and the judge struck that down. It's a purely financial obligation. We had a fascinating case. This is where we tweaked the document a little bit. I always say the document's not a Seres Adibris. We've been tweaking it all the time. But what happened was there was a situation in which a couple somewhere in Maryland were getting divorced, and the woman asked for a divorce, and the husband said, right, I'll give you a divorce today. I'll give you again today. Well, she wasn't interested in taking so fast. So they went to the Beth Din of America. It took 3 months till they got an appointment with the Beth Din. Why 3 months? Well, you needed husband and wife. Each one had a lawyer. In our Beth Din, we take lawyers, not Tawanim, for reasons maybe Rabbi Weissmann will have time to tell you why. And 3 judges. That's 7 people. To get them in a room, it took 3 months. Good. At the Beth Din, he says, I give it again today. She said, no. She doesn't want it today. Fine. Took 3 years for him to fight it out in court. After the 3 years are up, he gives her a get. No problem. Then he gets a love note from her. I need from you $100,000. $100 a day times 3 years. Please give me $100,000. He said, what? I was going to give you the get the first day. Came to our Beth Din, and it was a rare split decision. We have almost unanimity in our cases. Split decision. 2 judges said, it's very nice he came to Beth Din and said he's going to give a get, but the first 3 months, he didn't come to Beth Din. Now it was his fault, so he has to give it $10,000 for the 3 months. The 3rd judge says, that's ridiculous. He just wanted to come the first day. We couldn't get everyone together. He owes 0. In our Beth Din, there was an appellate division. You can appeal to the Beth Din or someone he designates. Both sides appealed. She wanted 100 and he wanted 0. So Rabbi Schwartzal designated me as the appellate judge. I worked on it, hard, and I wrote a decision. I worked, of course, originally in Hebrew. That's what I always do. I wrote a kind of a tshuva. Then I wrote it in English. He's obligated a total of 0. I followed the 1 judge against the 2. She was infuriated. Even the $10,000 she lost. She went to the court in Maryland to say that she should vacate my decision. Why? There's only 2 ways to vacate a decision of arbitrators. 1, corruption, bribery, ex parte, which in our Beth Din, we're not the best Beth Din in the world. They're bigger Talmidei Chachamim than us. But our record on integrity, no ex parte, and bribery, I believe is spotless. And therefore, the judge couldn't throw it out on that basis. She says irrational. An irrational decision can also be thrown out. So the judge comes back and says, irrational? That's a beautiful decision. It makes perfect legal sense. So that was a feather in our cap. That was that story. So we've had challenges here and there. Look, every judge, there's a judge somewhere who thinks it shouldn't be binding because it's sort of forced into it. Forced into it. You want to buy my house? Give me $5 million. You agree. And then you say, no, I was forced into it. I mean, it's absurd, but some judge wanted to say that somewhere. But as a rule, it's been upheld in the secular courts. Okay? So we're going along. Everything's fine and dandy. There have been objections on the grounds of asmachta, but more recently, I can name the rabbi because it's already printed now. His name was Rabbi Sternbuch, Shlita, one of the greatest rabbis of our time, who was provoked by an individual, whose name I will not mention, who was a troublemaker. I think that he wanted to promote a prenup of his own, but the way you do that is you knock down every other prenup. And he was so dishonest, he took signatures of rabbis from 1986, before our prenup even existed, opposing a different prenup, and he somehow cut and pasted it as if it spoke about our prenup, which didn't even exist at the time. But people who are have an agenda, don't always follow honesty. Anyway, so he got Rabbi Shlomo to mention our prenup by name, Histadrus Rabbanim, and say it's no good. Why is it no good? Because obviously it's a penalty. $150 a day. We moved it from 100 to 150 somewhere. Rabbi Weissmann will tell you what year, I forgot. It's ridiculous amount of money. It's crazy. So it's a penalty clause. And if it's penalty clause, a knas, oh, that's a Ramon, Kuf Lamadal, the knas, Machmas Asmo, is it good or no good? Ramon says it's good, but I have reasons to say it's not the way I have a Mishkanas Yaakov and a whole tshuva of 6 pages, all based on a false premise. All based on a false premise. We actually went to Rabbi Sternbuch a number of years ago, and we told him that, but whatever he did, but despite that fact, he put in this safer anyway. We tried our best. So these objections are all, reasonable for those who don't know the facts. Just recently, I attended a Kenes Dayanim in Yerushalayim. Spoke there just a month ago, the very beginning of July. And I had to get my facts straight. So I asked my economist from my shul, whom I had asked some years back, to check out if $150 a day is reasonable for the zip codes that we serve. By zip codes. He said yes at the time. And I asked him again to redo the numbers years later. He told me, except for a few zip codes that we hardly ever serve, the number should really be $200 a day. Just yesterday, someone called me yesterday. Why isn't it $200 a day? I told him, you're right. You're right. My economist just told it to me. But it's not necessary because likely is if we'll give it for 200, we'll give it for 150 as well. We don't need more detractors to say our numbers are exaggerated. He asked me, what about Eretz Yisrael? So I was asked that number. I asked around. There, our number is $75 a day because it's the cost of living is smaller. So this is the prenup. This is what it says. This is its history. And we feel confident that it's halachically valid, notwithstanding those who have various objections. Rabbi Bleich Shalita was a significant objector on the grounds of Asmachta, and I recognize his position. He said, we'll go back to Rav Zalman Nechemiah's original way, which was a little bit different. Instead of saying, I owe you the money from the time that we separate, which is Rav Tzimbalist's way, which, by the way, is not Chodesh Hashem in Torah. I believe it has a precedent in the Nachlas Shiva Simon Tes, which is the time of the Talmud of the Taz of the 17th century. He quotes him Takana Shum, goes back to the 12th century. It's true, Rabbi Usher Weiss, in his Haskama to our prenup, thinks that that's not a good precedent because there the only money is being given, so she shouldn't starve to death. And here, there's another possible agenda. My people who checked up the coins of the 17th century said much more than she didn't have to starve to death. So he feels that either way, it's not. I don't think it's chodesh at all. I think it's yosha nosha. In any event, it's halachically valid, and someone who wants to do Rabbi Bleich wants to do the opposite the way Rabbi Zalman Nechemiah originally. I owe you the money from today, from the moment of the. It's not a conditional obligation. I owe you the money every day. I owe you $100 a day, except as long as we're living together, you're meichel the chov. You separate, you're not meichel anymore. That's a wrinkle, which I would have done away myself, but the average American mind doesn't understand that. It's too complicated. Rabbi Bleich is famous for his complicated formulations, which are always accurate, but they're not amami. They're not for the average person. He doesn't understand these nuances. So since we feel that our position is correct, we stick with it. But someone wants to do Rabbi Bleich, I encourage him to do it that way. That's fine. The sad fact that most people in the Olam Yeshiva not using his, not using mine, not even using the Haskam, which has the Haskam of all their greatest Rabbanim. Inertia, just Shev al Tas Adif, which ordinarily is a very good thing. We're a very conservative, small C religion. We don't like changes. This is not a change, if I'm correct. There are other halachic intricacies. Rabbi Bleich thinks that the Nachas Shiva Simon Tes only worked because then they had the power of Hefker, Bez, and Hefker. They can impose it against your will. So they didn't have to agree. My counter to that is it's two parts of Europe. There was Ashkenaz and Poland. In Poland, This is all no secrets in the Piskei Teshuvah and Ebenezer. In Poland, it worked against the will. Even if you didn't sign it, it was binding. Not in Ashkenaz. So in Ashkenaz, presumably, it's not based on the Hefker, Bez, and Hefker. It's based on the person's agreement. That's my counter. There's much more to be said. This is just the tip of the iceberg. But I think I've spoken too long.
It's amazing. It's very eye-opening, especially we talk about Learning Daf Yomi, who are putting in the time to at least learn the daf. And they'll take some time, over the next few weeks, and these things stay around. So people, they get an interest. I want to learn about a topic. It's available. So to me, eye-opening and so much new information and so many things to talk about and think about. And there's two parts in my mind always. There's the Etzem Limud HaTorah, which was so much here to talk about. And then the practical application of it, which is what you intend, the Rabbi Willig, the Rav intended it to be for. And at least in some circles, it's going. And Mirz Hashem, as the Rav holds, it's a Chodesh Asam in HaTorah. So maybe at some point it will become a Yasha Nation and be more accepted. All for the help of Klal Yisrael, for the betterment of Am Yisrael and Klal Yisrael. So Rabbi Weissmann, you want to talk about a little bit from a practical sense of what you've been seeing beforehand? Obviously, you weren't around before prenup, but we discussed that you had wanted to talk about how it plays out somewhat at the end when they come actually for the get.
Sure, yeah, I'm happy to talk about that a little bit. For just picking up on the kind of controversy over the $150 versus $200. And as Rabbi Willig pointed out, it's not necessary because the $150 does the trick. I think that speaks to an important aspect of the prenup, which is that often we find when these cases actually get played out, the actual threat of a dollar support obligation, whether it's $150 or $75 in our Israel version, whatever it is often almost an afterthought and is even less important than the first provision of the prenup, which is the completely not controversial provision, which simply names a Beth Din. Meaning when people sign a prenup and it names the Beth Din of America, that already cuts past a whole part of a controversial divorce case, meaning a divorce case that involves potential recalcitrance. A lot of times those cases get caught up in the stalemate that exists when the wife wants to go to one Beth Din and the husband wants to go to the other Beth Din, and they can't agree. And then there's not an easy way to resolve that case. A seruv can't be issued because each one is prepared to go to Beth Din. It's just that they're arguing over which Beth Din. And so having a prenup signed that names the Beth Din of America or names a particular Beth Din that's a responsible Beth Din and will see to it that the get is arranged, that alone, setting aside any kind of monetary obligation, that alone has a huge toelis. And it speaks to the fact that, even in segments of our community that are less comfortable with Rabbi Willig's prenup for whatever reason, there is what to be said for advancing a prenup that just includes that first component. Even if the truth is, the second component is useful in some cases, that really cleans up what essentially every case, and it really allows it to have a full compliance rate and allows us to be successful in ensuring a get in virtually every case. But there's what to be said just for emphasizing the first aspect of the prenup, which is, naming a Beth Din.
Which is what Rabbi Willig mentioned before, is clearly Ramosha Feinstein already told Rabbi Per. That part was simple, pashut, and advisable.
I just want to add that Rabbi Weissmann is being kind. One Beth Din or another Beth Din. What about secular court? That's to my mind, even a bigger problem. Aside from the Israel cause, and I want to add one more point that I didn't mention before. In our prenup, there is an option. It's not mandatory because some women didn't want to sign, that the jurisdiction of the Beth Din extends not just to the issues of the get and the ksuba and this support agreement, but to all issues of distribution of property, of custody and visitation, everything. If that is signed, if all the monetary aspects are given over to the Beth Din, that's a simple solution to what we'll discuss later, the get law problem. The get law problem is a terrible problem because they can go to secular court and they can impose a penalty and all kinds of stuff. but not if you sign a prenup and include the financial part. So that's why it's an additional reason that should be supported for our prenup or for some other prenup, just to get out of secular court.
Yeah, the signing the optional problem kind of supercharges the prenup. It allows you to resolve not just one problem, not a problem of get recalcitrance, but also the problem of Isser Kos and the very practical problem that nowadays in the United States, it takes a long time to get a divorce. You end up paying lots and lots of money to lawyers. You end up fighting in court if you can't reach a settlement early on. You end up fighting in court for a very long time. There's some counties in New Jersey now, I think, who have just paused their divorce docket because they're so overwhelmed, and you end up just sitting for months and months and months, waiting for a civil divorce to go through, waiting for a trial date. It's a much more streamlined process in Beth Din. It's a halachically compliant process in Beth Din, I should say first. But there are a lot of practical reasons why it's good to sign that optional section, just giving Beth Din jurisdiction over all issues.
One more practical question, I guess a two-part question. So the RCA and Beth Din of America as a Beth Din, is there any, I guess to use the phrase, requirement that a rabbi should not officiate a wedding without a prenup, A, and B, just to understand, because I've seen people sign it years into their marriage. So how does that work?
Let me comment. Number one, that's what we call it a postnup. That is something which is primarily to create awareness. Primarily, we hope that after those years of marriage, they'll last forever in their marriage. But it's a show of support. I do also say that it should be signed well in advance. When a chos and kala come to meet me, if I'm a Masada Kiddushin, I try to sign it right then and there. In the yeshiva, we have plenty of Eidim, they come to see me. Right then and there, we sign it. It's not a good idea to sign it just before the wedding or at the wedding. There are for various legal reasons in certain states, and it's just unseemly if you ask me. So I don't do that. But I think that the critical nature is just to get it done. If it has to be getting done, then later. But the earlier the better. And I think that it's something which is workable, at least in our oilam. Will I serve as Masada Kiddushin if they refuse to sign it? My answer is yes. The RCA is not so happy with me because they want to make it, you have to do it. That's not my style. I'm not that kind of a person that say you have to do it my way or the highway. It's just not me. I will try to explain to them why it should be done. And, there's some people who just refuse to do it for various reasons, and sometimes they rue the day. But, I had a famous case. I used to go to speak in the high schools. I spoke in one of the famous girls' high schools. I was invited to come every year to speak to the high school seniors. A couple of years later, I got a call from a young lady whose family I knew quite well. Oh, she's in trouble. She's getting divorced. Well, what about the prenup? Oh, I don't have one. Weren't you there in my class? Sure. Why didn't you sign it? Well, the rabbi told me I didn't need it. Famous last words. Blood was spilled in that case. In the greatest rabbanim, I mentioned their names now. Blood. For naught, for nothing, for lack of a prenup. So, really. But, again, having said that, I still will do it. But I recommend that everyone should sign.
Okay, so Rabbi Weissmann, unless you have more to talk about in the implementation, I guess we could move on to the New York Get Law.
Sure. Yeah. The only thing I would add in terms of implementation is I see these cases on the other end, meaning we're talking now about signing it before the wedding, but unfortunately there are marriages that don't work out. People get divorced, and the Beth Din of America just sees the caseload. We see the numbers, and it's Eino Doma, a case where there's a prenup to a case where there's not a prenup. When there's a prenup in place, it's just a whole different flavor of a process. It moves smoothly. The Beth Din is empowered to send out azmanas, to schedule hearings, to see to it that a get is arranged, and a get gets arranged. There might be some pushback for the first week or two or three or even month, but the process is just so much more streamlined, and the woman is assured that there's a get waiting for her and that it'll be delivered in a timely manner. So that's the only thing I would just say anecdotally. It actually works. Like, there's a real difference that you could see between cases where there is a prenup and where there's not a prenup.
Okay, thank you. So let's quickly shift for our remaining time. It took a lot of Rabbi Willig's time already. Talking about the New York get law. I'm asking, I think on behalf of many, as an Amoretz, New York State get law. What does this mean? What's the history of it? Maybe why specifically New York State? And what have been the objections and halachic considerations for this New York get law?
I'll be very brief. In 1983, I believe, that's 40 years ago, there was a first get law, which Rav Moshe Feinstein Zatzal approved. That was a get law which said if you want a civil divorce, there has to be a get, and the person who sues for the civil divorce cannot get the divorce that he sues for unless a get is given. Of course, the problem with that is very simple. The man doesn't sue for divorce. The woman sues for divorce, in which case the get law is completely inoperative. So that's how it went. 1992, Rav Moshe was no longer with us. A second get law was passed. That's much, much more controversial. There's a concept in New York called equitable distribution. And many factors, it could be 12 or 13 factors. And they added one more, which says that the judge shall, if I'm not mistaken, that the word is shall, take into consideration if a barrier to remarriage has not been removed as an additional factor in equitable distribution. What that means in Mama Lashon, in plain language, is that the judge shall, which means he sort of has to, not quite has to, but shall, doesn't just say may or can, it says shall, take into account the husband's refusal to give a get, and on that basis, the judge will rule that you're not going to get the 50% you would have gotten otherwise. You're only going to get 30%. That raises the specter of a get meusa. Because we paskin la'alacha, not only if you beat somebody up, some of those sad cases you've read about recently with people that were in jail for beating people up, which also renders the get invalid in most cases. That's not for now. But even if you take away his money, it's also a get meusa. You take away money which belongs to him. That's exactly what this law is saying, giving the judge power to do that. So Rabbi Bleich said, and he wrote emphatically, with all the significance of what he's writing, he thinks that the default position is that every get in New York State is no good. Because every husband knows, or his lawyer knows, that if he doesn't do it, the judge can sock it to him. That's his position. And, the great Gedolim, Reb Shlomo Zalman of Yashiv, wrote then, this is not a takana, it's a sakana. It's a danger to the klal. Very serious danger, in my opinion. It's a very serious problem. Our Beth Din deals with this get law very carefully. We work very carefully to make sure that a get's not being given based upon that threat. We do the best we can. We think we get it right. If we think there's a threat, we will not do the get. The implicit threat that Rabbi Bleich refers to in every single get is a little bit far-fetched, because who said he objected to giving the get in the first place? Who said? There's much to be discussed whether that position is right or wrong. And Rabbi Bleich's position has not been accepted, as you said. Given they've been written for the last 30 years. I believe that probably, I don't want to say anything bad, I think our best is probably the most careful about seeing to it that an actual threat does not exist in case that we deal with. And sometimes we will just not do the get. But it is a burden. It was a burden before that law, but certainly a greater burden after that law.
Okay. I think well explained, simple and concise. Rabbi Weissmann, anything to add?
No, not really. I think that said it all.
Okay, so just to close, I want to thank both the Rosh Hashiva and the Rav and the Av Beth Din for a beautiful shir and explaining the prenuptial agreement and what the New York get law is. Thank you, Rabbi Weissmann, for putting this all together. And it should only be a schus for all of us. Lahagdul Torah lahadira. And we shouldn't know from Gittin. We should only have happy marriages. Ad bias gael tzedek, meherav yameinu.